Welcome to today's program titled, Could Cemex Cement a Union in Your Workplace? At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the meeting during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Jennifer Mora. Jen, please go ahead.
Thank you so much. Good morning or good afternoon, depending on where you may be dialing in today. We're really excited that you took some time from your busy schedule to join us to talk about Cemex, which is an NLRB decision that has really turned the labor world upside down. I am joined today by two amazing Seyfarth labor partners and colleagues. Jamie Rich is a partner in our San Francisco office. She's actually just down the hall from me. And Ken Dolan is a partner in our firm's Chicago office. Combined, this group brings almost 80 years of deep traditional labor and employment experience in all areas, including campaigns, elections, labor negotiations, litigating ULPs. You name it, this group has done it. So we have a lot to cover today, so I'm going to dig right in. Ken and Jamie, we've been hearing so much about Cemex. It's all anyone can talk about, so I'm wondering if you could set the stage and tell us what's the big deal.
Yeah, thanks, Jen. So I'll kick off just by saying that, the Cemex decision itself is one of the most clear shifts that we've seen in labor law in decades. This decision was a 40-page decision. There's a lot of nuance in it. There's a 15-page dissent as well. So we're going to go through some of the various issues today that are raised throughout the decision and questions that have come up since. So the Cemex case itself involved a bunch of ready-mix drivers, about 350 ready-mix drivers at about 20 different facilities. And these folks, the union gathered 207 authorization cards, and then they went through an election process. The union filed for an election, and a vote was held, an NLRB election was held, and the employees voted against the union by a margin of 179 to 166. So the union protested that, took it to hearing and went before an ALJ, and the ALJ ordered a rerun election. And so that teed up the board to take a look at this issue, and the board overturned decades of settled precedent, including US Supreme Court precedent, on how representation procedures work. And so I'm going to highlight here a few of the main changes, but basically a demand for recognition by a union can now trigger the representation process itself, even if the employer rejects the demand and commits no ULPs. So what does that mean? So there was case law that was in place that said if an employer receives a demand, they are under no obligation to really do anything. The union would have the burden to go ahead and file what's called an RC petition for an election, and then the parties would go off and have a vote. This case changed things by saying that the burden is now on the employer to file an RM petition promptly if it rejects the union demand. And promptly has a specific legal meaning within the case itself. There's a footnote that indicates that promptly means within 2 weeks. So now if you're in receipt of a union demand as an employer, your obligation is to file an RM petition within 2 weeks if you want to test the union's majority status or reject the union's demand for another reason. the decision does outline that, the employer could act at its peril and, decide to test whether or not the union has majority support in what we call an 8A5, so an unfair labor practice charge that deals with whether the employer is refusing to bargain. And if the employer is not able to prevail on that claim, then the NLRB can impose a bargaining order if the union can prove majority support in an appropriate unit. So this is a very large shift in how things are done when it comes to the NLRB and representation procedures. Just to be very clear here, an employer can take no action. So the case does say an employer, if they don't file an RM, they can still defend against that refusal to bargain charge and challenge a union's claim that it had majority support. So what does that look like? That looks like an 8A5 unfair labor practice charge being filed. It goes through a litigation process, and we'll talk about this in detail, but it goes through a litigation process, and then the employer can say, hey, I didn't think the unit was appropriate, or I didn't think that they had majority support because I'm aware of coercion or other things that are going on in the collection of those cards. And so the employer can assert those things. Notably, this decision is retroactive, which is fairly common with board decisions. It's sort of retroactive unless decided otherwise. And this is one of those cases where the decision is retroactive. So everyone should be aware of that if you have pending proceedings. And I'm going to turn it to Ken now to talk a little bit more about Cemex and some of the implications.
Thanks, Jamie. An interesting footnote in that this is probably the most significant dramatic change in labor law since I've been practicing, and I started practicing in 1982. Having said that, Cemex did not go as far as the general counsel wanted the board to go. The general counsel wanted the board, and we'll talk about this later on, the general counsel wanted the board to agree to the old Joy Silk principle, which you have much familiarity with, having given a presentation on that. And Joy Silk, and I'll talk about this in more detail, talked about unless the employer could prove a good faith doubt, if the union has majority status, the employer is required to recognize the union. So the general counsel did not get all of it, but I think most would say that the general counsel got most of what it was seeking. So this could be argued as Joy Silk light. In that regard, as far as what this really does, it puts much more weight on union authorization cards. Now, if the union possesses a majority of employee support as shown by union authorization cards, there will in many cases be an obligation to bargain without the formality of an election. That could be true if the employer either misses the deadline for filing an RM petition, or the employer commits even as little as one single unfair labor practice during the critical election period, sufficient to result in overturning the election. Now the default position where an election is overturned is not a rerun election, except in special circumstances. Rather, the default position for an unfair labor practice resulting in overturning the election will be a bargaining order. So with that in mind, I suggest that Cemex places much more weight on union authorization cards and reduces the reliance on NLRB secret ballot elections. And relatedly, it lowers the threshold for reasons I just stated as to when the board will require recognition and bargaining. So as you mentioned, and it bears repeating, when an employer confronted with a demand for recognition, and we'll talk about what that means later on, if the employer does not promptly file a representation petition, then the union could have the employer could have an obligation to recognize the union, even when the union's majority status is based entirely on authorization cards and the employer has committed no other unfair labor practices. That is a dramatic change in the landscape. Likewise, the board may now issue a bargaining order in circumstances for even a single post-petition unfair labor practice sufficient to overturn the election. without a finding that a fair rerun election could not be held. That too is a dramatic change in the case law. So it is vitally important now more than ever for employers to avoid cards being signed and to avoid even a single unfair labor practice during the critical election period. Jamie, anything?
Yeah, I'll just add quickly that with Cemex itself, you know, basically what the board was looking at was when you look at a Gissel standard, which was the prior standard, was the atmosphere so tainted by the employer's unfair labor practices that a fair rerun election is unlikely. So the board had the opportunity to answer sort of that question in this context, and instead they said, we're just going to change the standard, and the standard is going to be this much lower one, which is what Ken just described.
And related to that, Jamie, it's interesting that the administrative law judge said that the unfair labor practices didn't satisfy a Gissel bargaining order standard at all. The board obviously reversed that finding as well as issuing the new Cemex standards.
Right. Yeah, very interesting stuff.
Yeah, it is very interesting. Thank you. So it's possible many on this call do not know what a demand for recognition looks like. So Ken, can you talk more about what it is and what an employer should do once it receives a demand?
Sure. What is a demand? It's really any request from the union to the employer for the employer to recognize the union as the representative of employees in an appropriate unit. The demand need not be made in any particular form as long as the request clearly indicates a desire to negotiate and bargain on behalf of employees in an appropriate unit. And it could take many forms. It could be an oral statement, it could be a written statement, it could even be checking the box in the RC petition that the union may file, as long as the union checks the request for recognition box on the NLRB petition form. So in many cases, even if there's no formal letter, you could still have a viable demand for recognition based solely on the petition. Note too, and this is most important for the attendees, I believe, the demand need not be made to any particular officer or registered agent of the employer. There's actually a bad case law from 1971 where demand for recognition on a warehouse manager was found valid, a warehouse manager, and that demand was found valid despite his protestations that he was without authority. The name of that case, for whatever it's worth, is Central Distributing Company. What are the options? The second part of what you asked, I believe the employer has 5 options. 1, it could agree to recognize the union, or you have it listed differently, so I'll follow yours. 1 is voluntarily recognize, okay. 2 is to agree to a card check and be bound by it. Note though that a card check procedure will not toll the 2-week deadline that Jamie referred to earlier. 3 is to promptly file or 3, the way you have it is if an RC petition is filed, just await that process. Then the employer need not do anything. It has the option of filing RM, but it need not file an RM. 4, if no RC is filed, then the employer must, as Jamie pointed out, promptly file an RM within 14 days to test majority support, the appropriateness of the unit, or both. 5, do nothing and be prepared to defend an 8A5 unfair labor practice charge by showing that the union can't prove that it represented a majority in an appropriate unit. That may be difficult in most cases, but it is an option that's out there.
Jamie, any thoughts?
Yeah, if I can, I just want to go back to the piece about the valid demand. No need to change the slide or anything, but I'm sure folks are wondering, well, how does that work? And there's a GC memo out there that came out after this decision was issued that basically talks about, the demand need not be made to any particular person. Ken mentioned that there was this warehouse manager in one case that was deemed to qualify. But basically, if you're an authorized agent in any form on behalf of the company, I think arguably if you have the ability to hire or fire or engage in statutory supervisor, indicia, then I think this particular board is going to say, yeah, you are on notice. And so I think this presents a real conundrum for employers to try and figure out, okay, how do we make sure that we get notice of this if it happens, right? So there's sort of the piece of, hey, do we have a demand and how do we know about it? And then there's this other side, which is what do we do about it? And I think Ken just laid out the options really well. There are several different ways that you could go.
Yeah, and we'll talk a little bit more about this later, but it sounds like training managers and supervisors or anybody who might potentially receive one of these is going to be highly critical. So we keep hearing about RMs and RCs, and Jamie, I'm wondering if you can talk to us about what we think employers and unions are going to do.
Yeah, so just to deal with a little bit of the jargon here, and I know I referenced it earlier on, but when we talk about an RM petition, what we mean is a petition for an election that is filed by an employer, as opposed to an RC petition, which is a petition for an election that is typically filed by a union. So really that's just dealing with who's filing it. But in either case, that petition is going to say what the unit that's being demanded is, and it's going to have all sorts of various information about the petition that's being filed, how many folks are in the unit and things like that. And so, with respect to what we think folks are going to do, surveying the docket and looking at what's actually happening with the NLRB after this decision. This decision was issued at the end of August. So it's been a few months. What we're seeing is that really unions are continuing to heavily rely on RC petitions. There are still RC petitions being filed, even though the union does not have the burden. RM petitions, some are being filed. We are seeing those in lower numbers generally than the RCs, but there are definitely cases where employers are filing RMs under this new decision. And I think it's yet to be seen how this process plays out and what those elections will look like. And there's a whole host of procedural issues that are raised by the RM petition. I know that the board or the regions are still in the process of working through, I believe, a case handling manual for how do these things actually work, because it does change things procedurally a little bit for them. So, some of that is TBD. But one thing that we know for sure is that, when folks do file either an RC or an RM petition, the rules are about to change. The election rules will be changing the day after Christmas. So happy holidays to everyone. And we will be moving forward with what we sometimes refer to as the quickie election rules. They're largely the rules that were in place in the Obama era and that were issued under that administration, which just means that statements of position are due sooner. So, either the employer or the union saying what their position is about whether the unit is appropriate and whether there are certain other issues, supervisor taint, issues of coercion with the cards, problems with the cards, things like that. Notices will have to be posted sooner. Regional directors, the folks working at the region will have less discretion to extend deadlines and postpone hearings. So you get a hearing that's typically 8 days after the petition is filed, and you are off to the races on that with very little ability to get that extended. And there are new limitations on what can be litigated at a hearing. This was in place during the Obama era as well. So, eligibility and inclusion issues are typically pushed off to the post-election stage. So they would have the election first and then figure out whether the folks who actually voted were allowed to vote on the back end. The other piece that's really key here, at least for us as attorneys, is that briefs are generally not allowed, which means that when you go to this hearing, you are arguing everything there, your closing argument and everything. You're trying to make sense of the record and all of that at the hearing itself. And then, I think this last bullet here under the key changes is the most important one, which is that regional directors are to schedule elections at the earliest date practicable after issuance of a decision and direction of an election. And so what that means in terms of timing, when you look at all these things together, in the Obama era, the election rules, I think the average was like around 24 or 25 days. I don't have the exact number in front of me, but it was very quick, as opposed to the 40 to 42 days that you would have under the current rules, which are about to change. So hopefully that makes sense. But basically, you're going to see these cases move on and into an election within about 3 to 4 weeks, which is very, very fast.
And Jamie, when are these rules effective?
December 26th is when they're set to go into effect.
So just around the corner. Okay, helpful. So Ken, you mentioned that one of the options an employer can take if it receives a demand is to, ignore it or do nothing, which would mean that the union would file an 8A5 charge. So I'm wondering if you can talk to us, and again, assuming neither side files a petition, what would that look like from, an investigation standpoint by the region?
Well, the union would file a charge in this case, and it would have the burden of showing that it represented a majority of the employees in an appropriate unit. It would show evidence of cards, typically signed by a majority of employees in that unit. The board would do some investigation at the regional office level to determine whether or not a majority does exist. And I would say practically a cursory examination as to whether or not it is an appropriate unit, right? There has to be an appropriate unit finding, meaning that the group of employees that the union is seeking representation for shares a community of interest. It doesn't have to be the most appropriate unit. There could be more than one appropriate unit. And the board, especially this board, gives a lot of deference to the union's request for unit. Not total deference, but much deference. So the two issues that would be investigated: does the union have majority support, as shown by authorization cards typically, and is that in an appropriate unit? If the burden is on the union, if the union cannot meet its burden, the region should dismiss the charge. If the union can meet its burden, then it goes to a hearing, and the employer is free to defend by showing at the hearing stage, post-complaint, that the union cannot establish that it represents a majority of employees in an appropriate unit. That's typically done not only by the representation issue of it's not an appropriate unit that the union seeks, but also by showing that a majority of the employees didn't sign cards, or the cards were somehow tainted, either by being obtained by virtue of coercion or fraud or misrepresentations, or the employee that signed it wasn't part of the unit that the union seeks, or the employee left, or the employee changed his mind and revoked before any unfair labor practices by the employer occurred. So that's typically the hearing stage. An administrative law judge would hear the case, make recommendations to the NLRB as to whether or not the employer violated its obligation to bargain, i.e. whether or not the union represented a majority of employees in that appropriate unit that it seeks.
Ken, one question that's come up in the chat that I'm not sure we addressed earlier with respect to a valid demand is, when the union makes a demand, does it have to define or tell you the unit in which it seeks to represent employees?
It should, and that makes it easier, and typically it will, but that could at least initiate discussion. So in the our case form, and that's why this is usually not going to be an issue, because if the employer doesn't agree, in many cases the employer will, or the union will file an RC petition. It will check the box, and the union unit will be on that representation form. In cases where it doesn't disclose, the employer will, in most circumstances, as one of the 5 options, file the RM petition that Jamie talked about, in which case it will enunciate what it believes the appropriate unit is, particularly if it doesn't have any contrary unit proposal from the union. So that's going to get ironed out in virtually all circumstances early on in the process. But the short answer is, in many cases, initially the demand may not set forth what the specific unit is.
That makes sense. Okay.
I'll just add to that just briefly, having seen this issue play out a number of times, and Ken, I know you have as well, there are frequently questions between, the employer and the union about, okay, the union is raising some classification. We don't have anything that's called that as the employer. Like, how do we know what this unit really looks like. And so, you know, there is still that pre-election process where the parties go back and forth on the unit and say, no, what we really meant was this, or what we really meant was that. And so there's some negotiation in that. Where I think this really is going to be an issue is what you were just talking about, Ken, which is in the demand context where no one files a petition. And the region is left to try and figure out on an 8A5 unfair labor practice charge, what was the union demanding if it's not clear in their letter, or if what they, you know, state either in their letter or orally is something that's a classification the employer doesn't have. How does that work? I think it'll be interesting to see that one play out.
Yes, and initially, I agree. A lot of times the union's not going to be specific. Ultimately, the union has the burden of showing that the representation it seeks is in, quote, an appropriate unit. So ultimately, the union has to disclose, but it may not be at the outset of the process.
That's interesting. And one of the questions that actually just came in the chat, and I know we need to move on, but I'm hoping one of you can real quickly touch on what does it mean for a unit to be an appropriate unit?
I'm sorry?
What does it mean? Somebody asked in the chat, what makes a unit inappropriate? So can one of you discuss that real quickly so we can...
If they don't, if the unit, the grouping is found to have an insufficient community of interest when looking at wages, hours, terms and conditions of employment, including benefits, including who supervises them. One of the key factors, if I had to say what is the number one factor, look at the org chart of the employer. That's typically what the board uses at the outset to determine, is this grouping consistent with how the employer organizes its business? And then the questions I mentioned about community of interest, wages, hours, terms or conditions of employment, who the managers, supervisors are, is there interchange between different subgroups of employees? All of those factors will be looked at. And then the board decides, is that sufficient to find it that the unit sought by the union is, quote, an appropriate unit. Remember, again, it doesn't have to be the most appropriate unit. The only way the employer could get relief from that is by showing that the unit sought by the union is inappropriate. It's not sufficient for the employer to show there's a more appropriate unit out there. Jamie, anything to add?
No, I was just going to add that piece, that it's an appropriate unit. It doesn't have to be the most appropriate unit that exists, and there's plenty of board law on that issue. Some may be thinking of the micro unit decision that came out recently as well. So to see how that plays out here will be interesting, but I expect it will play out much in the same way that, you know, it's played out prior to this decision, which is that an appropriate unit, the union sort of puts forth what it thinks the unit should be, and the employer then has to show, you know, all these various legal standards to show, no, it should be something else.
Yeah, and, you know, as the two of you know, we have a lot of experience among this group litigating that issue. It seems to be one of the most commonly litigated issues before an election. So that was very helpful. So I recently did a webinar on Stericycle, another board decision, so employers can understand the NLRB's views on handbooks and policies. And Jamie, why are we now talking about Stericycle yet again and this new decision, McLaren?
Yeah, so there's a footnote in the Cemex decision that indicates that under some circumstances, a overbroad handbook policy could be enough to, previously it would have potentially set aside an election, and now it would be enough potentially for the issuance of a bargaining order. There was a lot of back and forth on this issue, actually, with the majority referencing the dissent and the dissent referencing the majority, and them sort of taking issue with each other's positions on this. But footnote, I believe it was 188, the board, the majority did come forward and say, well, under some circumstances, yes, a handbook violation would be enough. And so this goes back to when Ken was describing the decision earlier and was talking about even a single ULP, if it's enough to interfere in any way with the election, that now it's not going to result in a rerun, it's going to result in a bargaining order, which just makes it all the more important for employers to be aware of the new handbook rules and work rule standards that are being set forth by this board. So we thought, you know, a lot of you folks may have already attended webinars. To Jen's point, she just gave one recently. So we don't want to get too much in the weeds here, but we wanted to give a quick recap, which is that under McLaren-Macomb, the NLRB held that employers may not offer severance agreements that require employees to broadly waive their rights under the NLRA, and really was focusing in on confidentiality. So it doesn't have to be in a severance agreement necessarily. You could see it in just a standalone confidentiality policy, or in an offer letter, or in some other type of NDA. What they're really focusing on is if you tell employees that they can't talk about their terms and conditions of employment, or if they can't protest various things, that's going to be deemed a violation. And then Stericycle, which came out after McLaren, went even a little bit further and basically changed the standard for how work rules are analyzed. And so now this board says that a facially neutral work rule is presumptively unlawful if a reasonable employee who is economically dependent on the employer and predisposed to engaging in protected concerted activity. So you're a person who wants to engage in, you know, some sort of union activity or PCA. So, you know, that individual, if they would interpret the rule to have a coercive meaning, then it's going to be overbroad. The employer can rebut the presumption by proving that the rule advances a legitimate and substantial business interest. And that itself is not much of a change. However, now you have to also show as an employer that it couldn't, the legitimate business interest could not be achieved by a more narrowly tailored rule. So the narrowly tailored is really going to be the focus now. You know, is your handbook and are your work rules tailored enough to meet those standards while advancing those interests? And that is going to be a really, really tough standard to meet, I think, for a lot of folks. Ken, did you want to jump in?
I wanted to just go back and tie this to Cemex again. And that is, it's true that not every single unfair labor practice will automatically result in a Cemex bargaining order. I believe employers should not take much comfort from that, given the existing case law and the propensity of this board. Because number one, under the question is, will the unfair labor practice be sufficient to overturn the election? In most cases, it will be, and that's for a Section 8A1, and I apologize for getting granular, but a Section 8A1 violation. And there, the existing case law says, ordinarily, even a single 8A1 violation will result in an election being overturned unless the violations are so minimal or isolated, and here's the operative phrase, that it is virtually impossible to conclude that the 8A1 violation affected the election result, given the number of violations, severity, the size of the unit, the number of employees. But let me tell you how the board has interpreted it historically. And this Biden board is more pro-union than the boards I'm referencing. But there was a case called Intertape Polymer Corporation in 2016, where the board found a single violation based on the removal of union literature from a break room 1 month before the election warranted setting aside the election, even though the final election result, this was the only violation found, was 97 yes and 142 no. Secondly, in Diamond Walnut Growers, the board set aside an election based on a single unfair labor practice affecting only one employee in a unit of 1,300 employees based on, quote, implicit dissemination. So I submit to you that this virtually impossible standard will be virtually impossible to prove before this board.
Yeah, it's interesting. And, you know, just real quickly on the handbooks, the key policies, I mean, really got to look at your entire handbook, but the key policies are solicitation, distribution, social media, bulletin boards, uniforms. We've been hearing about uniform policies. So we'll talk at the end about recommendations for employers, but Stericycle is a big deal for us.
Yeah, and I think before we move on, Jen, I just sort of want to double down on what Ken had explained earlier about the even a single ULP is enough. So yes, you know, we care about handbooks, we care about work rules, you know, all of that, but also what we would typically think of as an 8A3, so a retaliatory discharge or discipline, things like that. Those are going to be enough. There are other types of what we call an 8A1 charge, types of coercion and things like that that could be enough as well. So some of you may have had what we call TIPS training, that employer cannot threaten, interrogate, make promises, or surveil employees who are engaged in PCA. Any of those types of things are going to be sort of up for grabs. And I think we're going to see unions file charges. I mean, they frequently do anyway, right? But I think we're going to see increased numbers of charges on various things. Unions now will really have an incentive. I kind of think of it as, if you're in the middle of a representation case now, this is the union's insurance policy, right? Like, they're going to file charges saying your handbook is overbroad, you threatened somebody, you disciplined somebody improperly, and all these other things. I also see something in the chat here asking about captive audience and the GC's take on that. So as some of you know, the general counsel of the NLRB issued a memo, I believe it was last year even, talking about captive audience meetings, which are these presentations that employers sometimes hold to inform their employees about unionization, what it means to join a union, what signing an authorization card really means to them, what the company's position is on unionization, those types of things. And the general counsel has taken the position that to the extent an employer has employees attend those types of meetings on work time, and those meetings are mandatory, that would be a violation of the act. Now, there has not been a board decision that's come out on that issue. But again, as I mentioned earlier, the typical practice is that when decisions come out, they are retroactive. And Ken, I don't know if you're reading the tea leaves at all on this one, if you think that decision is going to come out, or what we think folks are going to see.
Well, the board has delayed and deferred addressing that issue, but I think eventually it will come out. And as you pointed out, the general counsel, this is a big issue for the general counsel. And she says the only time that these group meetings should be permitted is if it is clear that the meetings are voluntary, and there are 4 portions that the employers must provide to ensure that these meetings are considered voluntary, including expressly stating that to the employees, expressly stating that they're free to leave, that there be no retaliation against them if they don't leave, and the like. So I do think this is an area that the general counsel is pursuing, particularly if there are other unfair labor practices. And I think the board, unfortunately, will not go in the employer's favor on this issue.
Yeah, we could probably.
Go ahead, Jen.
Go ahead. No, I was going to say we could probably spend an hour talking about this, but I do want to make sure we get through the rest. Did you have one more thing to add in, Jamie?
I was just going to say, to the extent you're in the middle of a representation case and, you're deciding whether or not to have captive audience meetings with employees, I mean, definitely take the Cemex framework into account and balance those risks.
Agreed. Okay, so Jamie talked earlier, Ken, about recognition demands before Cemex, and I'm wondering if you can kind of just give us some brief historical background, because one of the questions that's already been asked in the chat is, please tell us this case has been being appealed. So tell us about the historical background, please.
Sure. And I'll start out by I'll talk about 3 cases: Joyce, Silk, Gissel, and Linden Lumber. And I'll start with Joyce Silk, which is a favorite case, certainly of the general counsel. Jennifer Abruzzo believes in Joyce Silk, and I want to back up for a minute so you understand her thought process as the general counsel. She makes the decision whether to prosecute cases ultimately. And her belief is that the most valid indicator as to whether employees support a union is whether they signed an authorization card. And many management folks, including me, beg to differ. Employees sign an authorization card, even leaving aside even the fraud issues, just because they don't understand the many, many disadvantages of unionization. And maybe they're upset with the company, so maybe it's legitimately signed, but they don't realize the consequences. And I have found, and I'm sure Jamie has, and Jen has, and everybody who has done many of these, including many people in our audience, have found that you can lawfully provide facts to the employees to get them to voluntarily change their mind on union representation, even many of those who initially signed a card before they understood the many disadvantages of union representation. That's what I believe. I suggest that's what many of our clients believe. That's not what Jennifer Abruzzo believes. She believes the truest indicator is whether they sign a card before any employer communication occurs. And that sets the framework for Joy Silk Mills. In Joy Silk, the board took the position that an employer, when confronted with the demand from a union based on a card-based majority, had an obligation to bargain with the union unless it could prove it had a good faith doubt to question the majority status. That was the law in 1949, and for about 20 years, the law has taken a pretty circuitous route in the sense that what do they look at? What does the board look at to determine what's a good faith doubt? Who has the burden of proof of showing whether the employer had a good faith doubt? Must there be unfair labor practices? Must there be serious unfair labor practices? What happens if the employer just says, I don't believe it and I want time to convince the employees? Those questions were answered differently depending on the time in the 20 years following Joy Silk. I should add at this point that when Jennifer Abruzzo started talking in the last couple of years about Joy Silk, we had one of our co-panelists give a very persuasive presentation to a group of labor lawyers about why Joy Silk was ineffective, was improper, and I suggest to you that the General Counsel was not happy at hearing that rather persuasive presentation by our own Jamie. But nevertheless, it was an excellent presentation. I digress.
Thanks,
After
Ken.
Joy Silk, Gissel Packing came up. And that is perhaps the most significant case in board standards, at least in the last 50 years or so, or 55 years. During oral argument, the Supreme Court justices questioned the board attorney with regard to the viability of Joy Silk because it had gone around and it had so many different nuances. And the board attorney stated that the board had, quote, essentially abandoned Joy Silk. Well, that was raised by Jennifer Abruzzo as a terrible mistake. I question whether that was a mistake. I think the lawyer just wanted to make sure that Gissel got at least somewhat enforced. And so that debate continued. Gissel Packing, though, was interesting. The Supreme Court held that where a union at some point achieves majority status through cards, that there can be a bargaining order issue where the atmosphere is so tainted by an employer's unfair labor practices that a fair rerun election is unlikely. So in the first case, it would be a bargaining order is issued if it's virtually impossible. The second case, unlikely, therefore bargaining order, but there has to be such a finding. And in making that determination as to whether the bargaining order was appropriate, the Supreme Court specifically held that the board must conduct a case-by-case analysis, taking into account the extensiveness of the unfair labor practices, as well on their past effect on the election conditions and the likelihood of their recurrence in the future. So the Supreme Court expressly recognized that there's a category of cases that existed involving minor or less extensive unfair labor practices that because of their minimal effect on the election machinery would not sustain a bargaining order, and that the preferred method of determining whether the union has majority support is a secret ballot election. And so even if there are some minor or isolated unfair labor practices sufficient to overturn the election, nevertheless, the preferred option is a rerun election, not a bargaining order. And this standard has continued to be in effect for 50 years, though the board and the certain courts of appeal have applied this standard differently. The board's focus has been to look at the time in which the unfair labor practices were committed. Some courts of appeals, including the DC Circuit, have considered changed circumstances, including the passage of time since the unfair labor practices were committed and any resulting turnover in management and employees in determining whether the bargaining order is an appropriate remedy at the time that it is entered. That's a much later time than when the unfair labor practices were committed. As a result, courts of appeal have often refused to enforce GISL bargaining orders when the board has failed to provide a sufficient justification as to why a bargaining order, as opposed to a rerun election, is warranted. And the board has had trouble getting its bargaining orders enforced in many courts of appeal. To finish the discussion, Linden Lumber, the 1974 case, the board formally abandoned Joyce Silk and held that the employer did not act unlawfully based solely on its refusal to accept evidence of majority status other than the results of a board election, and that a union with authorization cards purporting to represent a majority of employees, which has refused recognition, has the burden of taking the next step in invoking the board's election procedure. The board explained, and the Supreme Court agreed, that it did not want to re-enter the, quote, good faith doubt thicket of Joyce Silk. I should note that the DC Circuit actually reversed the board and found that the employer refused a request for bargain based on a card majority was illegal, and it was a 5-4 case that the Supreme Court upheld the board's interpretation, rejected the DC Circuit's contrary decision. The court found that the legislative history supported the notion of not putting the onus on the employer to file an RM petition, and disagreed with the circuit court's belief that the employer should be required to file an RM petition. And the Supreme Court observed implicitly that the board's holding was a proposition that an employer can refuse to recognize a card majority, and that the employer has no duty to file an RM petition. Cemex wiped away all of those principles in one giant swoop. It wiped away all of those principles, the notion that it's the onus is on the union to file if the employer rejects a demand for recognition. It rejected the notion that there had to be serious unfair labor practices to justify a finding that a fair rerun election could not be held. I rest.
So do we think, good case, do we think it will be reversed on appeal? What's going to happen?
I actually believe it will be. I'm not certain, because there is a lot of deference given to agency decisions. But I can tell you that Cemex does conflict with Linden Lumber. And I would argue that based on Linden Lumber, as well as the legislative history cited in the Supreme Court decision, the board is not permitted to place the onus on the employer to file an RM petition, point one. But more fundamentally, Cemex conflicts with GISL packing.
Yeah.
I submit that the board cannot issue a bargaining order for employer misconduct without first engaging in a case-specific analysis, as GISL stated, and that a finding of a fair rerun election cannot be held because there has to be a finding, that a fair rerun election cannot be held before you issue a bargaining order, because, as the Supreme Court pointed out in GISL, a rerun election is the preferred remedy for employer election misconduct. So based on Linden Lumber, the legislative history, GISL packing, I submit there's at least a very good chance that this Cemex decision would be overturned.
So I do want to jump in here. Yeah, I do want to jump in here and just say for folks who had asked that this has been appealed. Cemex did go ahead and file its appeal promptly. In this case, actually, the union also filed a sort of its own appeal or counter appeal And so it went to the multi-district litigation procedures, and this decision in the first instance will be decided by the Ninth Circuit as opposed to the DC Circuit.
Yes.
And so I do think that that may impact in the circuit courts what we see here. I do think that there's going to be more of an uphill battle to try and overturn this in the immediate future. But then I do think hopefully this will go up to the U.S. Supreme Court. And I think with the Supreme Court sitting, I think a lot of the things that Ken just said are going to come into play and are going to be arguments that they will consider.
And with all due respect to you, Jamie, and to Jen, because I know that you are both based in California, the Ninth Circuit is the absolute worst circuit to have this appeal pending, as you probably both are well aware.
Yeah.
Yes, no offense taken. We do not sit.
Well, I want to say we have 10 minutes left, and I want to get to, I think, the heart of what probably our attendees want to hear, which is what should they do now? Before we get there, though, I do want to read the CLE code. It is SS as in Seyfarth Shaw 1212 SS 1212. So, Ken and Jamie, what do our employers need to do? What are you recommending everybody do in light of all of this that you've just told them about?
Yeah, so I think I'll just kick this off. The first thing is, the same, sound advice that we tend to give employers over and over, which is create positive relationships with your employees. There are, programs that some employers undertake to really look at certain issues and try and fix issues and try and really communicate with their employees. A lot of that starts, the ground up with those frontline supervisors really, acknowledging and understanding where employees are coming from and just dealing with the day-to-day, the pebble in your shoe type stuff. The other thing I think is educating employees on the company's labor relations philosophy. I don't think that employers should be as afraid to say the word union. I know a lot of employers tend to want to sort of hold off and not say anything until it gets to a point where they feel like they need to address the issue. But this really has brought the labor realm, to the forefront. And I think non-union employers or employers that have a part of their workforce that's not unionized definitely want to be thinking about these issues early. And probably this third bullet here is the most important, which is educating your employees early about authorization cards, what they are, what they mean. And to Ken's point, even if you're not talking about coercion, there are plenty of employees who sign a card just not knowing what it is. I can't tell you the number of times I've heard an employer ask me, what do I do now? An employee wants to get their card back because they just understood what they actually signed. So early education is incredibly important. And then we always advise that folks actually know what warning signs are, understand what those warning signs are. So if employees are, calling in sick more frequently, becoming silent when managers approach, things like that, you may have a tip-off that something's going on. And really training, right, to avoid those ULPs. I mentioned tips earlier, so avoiding threats, avoiding interrogations, unlawful promises and surveillance of employees. Some of these things can be a little bit counterintuitive, right? Like I always use the example of interrogation. Like you go up and ask your employee, hey, what's wrong? What is everybody so worked up about, right? In the right context, that could actually be, an unfair labor practice. And so I think knowing what the bounds of the law are and how to phrase things and how to talk to your employees is just so key to make sure that you're not getting those unfair labor practice charges to the extent that that's possible. And then finally here, and I'll see if Ken wants to jump in on this one, but educating managers and supervisors on how to lawfully reject a union's demand for recognition. Ken, you want to take that one?
Well, right. I mean, obviously, if any supervisor and manager is confronted with the demand for recognition, they should communicate that to the people responsible for labor relations, and they should not accept it. They should indicate that it's not being accepted, and they should be trained not to accept it and to bring that to the attention of executives. And on your slide panel there, Jamie, it can't be overemphasized how important now cards are. So I would underscore that. A lot of the training mentioned unions, but not about cards. It's vitally important now more than ever. Employees should not sign cards if they don't intend to vote for a union. And here are the reasons why a union is bad, and here are reasons why you shouldn't sign cards unless you're absolutely committed to the union, which in many cases employees are not. Want to go to the next slide? Again, it's important when there is union organizing that we be vigilant regarding supervisor taint or involvement. For many clients, a rapid response team tends to work to train them because, as Jamie pointed out, less time now with the new election rules with quickie elections. And relatedly, it's important to know about the new timelines because they are quick. And many clients believe it's worthwhile to have their campaign materials prepared in advance because you're not going to get most time in most cases for an extended campaign the way you did even a few years ago. The last two, I would say, are most important, in addition to the cards. And those are, there has to be a review of work rules and policies and practices and handbooks. Yes, you could basically say, well, we'll just deal with this on the appeals side, but most clients don't like to spend that kind of money for appeals all the way up to the circuit and maybe even the Supreme Court, and hopeful that the board law will change. And remember, review the work rules, review the policies, review the practices, review the handbooks, because even a single violation is enough to trigger Cemex. And then finally, post-petition, communications, handouts, and speeches have to be reviewed more carefully than ever before. I've heard some of my colleagues at other law firms say they recommend that the employer only engage in written or only use written communications. I don't like that. I think in most cases, oral communications are most effective and written communications supplement those. But the reason why is not irrational. Any single post-petition communication or handout or speech that is found to be unlawful by this board is going to likely be sufficient to trigger a Cemex bargaining order. So I urge you to pay attention to your work rules and practices and your post-petition communications. Jamie?
Yeah, I think that's right, particularly that last one. I mean, employers are now faced with a very difficult decision, right? Because oral communications are just so much more effective, but a lot of the litigation in this area, you know, if you are going to have a ULP about something that a supervisor said, is going to involve a he said, she said sort of a case. And so I think I would probably hedge that, Ken, and say, have your written communications, have your script, know what folks are supposed to be saying, and have them trained so that they're following that script, and you have something that you can show later to say, no, what they said was this. You know, to the extent you can do that, I think it's helpful. I don't know. I don't know if I would completely abandon just talking to your employees, right? Like that's, yeah.
No, I don't recommend that, as I mentioned. One other thing I would add here and turn it back to you, I think in addition to the communications, and it goes without saying, also all post-petition discipline should be carefully reviewed. That's going to be problematic even under a GISL standard and certainly under a Cemex standard. And all discipline should be reviewed. I believe lawyers should review all discipline before it's meted out. Jamie, I don't know if you have any thoughts on that as well.
Yeah, I agree with that. I mean, definitely if you're thinking of disciplining or discharging somebody during one of these, I mean, that is going to be one of those hallmark things that is going to land you in hot water potentially. So really, I wouldn't say, you know, in every case that you can't do it, but it's going to be tested. So just be aware, call your labor counsel. That's what I would say.
Well, on that note, we are out of time. This has been extremely interesting and informative. I hope it was helpful for all of you. We did our best to answer questions that we heard in the chat, tried to address them, but if you do have any follow-up questions, please definitely reach out to us. There's our contact information. The deck will be shared, and I know a recording will also be going around. So thank you all so much for taking time from your day today to listen to us. We really appreciate it. And Would love to hear from you if anybody wants to reach out. Have a fabulous day. Thanks, everybody.